The next matter before the court is State of Ohio versus Patrick Graham. The appellant may have 5 minutes for rebuttal. If you wish to reserve that time, please let me know.
Thank you, Your Honor. Good morning. May it please the court, Mr. Viglucci, Michael Ash, on behalf of the appellant, Patrick Graham. And Your Honor, I would wish to reserve 5 minutes of time. The factual matters in this case are quite simple, and I believe that the state of Ohio and the defense were in agreement as to many of the elements of the offense. What is before this court today is the issue of whether or not the trial court erred in finding that the motion to dismiss would not be granted. The foundation for the motion to dismiss was that this court, the Court of Common Pleas, did not have jurisdiction over this matter as it should have been charged as a misdemeanor. On October 7th, 2015, Mr. Graham was indicted on a single count of violation of a protection order, which normally would be a misdemeanor of the first degree. In this case, it was elevated to a felony of the 5th degree. The state's basis for elevation was what they deemed a prior conviction in September of 2015 in the Medina Municipal Court. On September 14th, 2015, Mr. Graham had pled no contest to violation of a protection order. He was given an OR bond and had contact with the protected person that same day. That was the basis for the indictment in this case. In Mr. Graham's Medina Municipal Court case, to which he had entered a plea of no contest, sentencing was scheduled October 14th, 2015. He was indicted in this case October 7th, 1 week prior to the sentencing. So the basis for the appeal is there should not have been an elevation of the sentence, of the charge, because there had been no sentencing hearing. In this case, Mr. Graham did not enter a plea of guilty, which is one way that the statute provides elevation of the offense. The other way is a conviction. And as this court cited in Gwen, and the Ohio Supreme Court has also cited, the conviction is not only a finding of guilt, but also a sentence. And because Mr. Graham was not sentenced until a week after the indictment in this case, our position is there was no prior conviction for violation of a protection order, so this should not have been elevated from a misdemeanor to a felony.
What is the requested relief in the motion to dismiss? Is that the trial court's only option if it's faced with that issue? If it's sitting there after a plea of no contest, or I guess guilty, but, and sentencing hasn't occurred yet, is its only option then to dismiss?
Is the trial court's only option? No, I think what could have happened, and this was placed on the record at the trial court level, the matter could have proceeded to trial, and the state would have bared the burden of proving the prior conviction. But on an agreement between defense, the state of Ohio, and the court, Mr. Graham was allowed to plead no contest to the felony level case with a specific exclusion as to a prior conviction, so that this matter could be appealed to the higher court and have this court review whether there should have been an elevation to indict on a felony or whether Mr. Graham should have been charged with a misdemeanor.
But the trial would have been whether or not there was a conviction, not whether or not he was guilty of the prior offense, right?
Correct. Right. It would just be that's one element of the offense, the prior conviction. So the merits of that case would not have been on a retrial, just whether or not there was a conviction. And I believe Ohio law would have required the conviction to be proven by not only the plea, but also the sentencing entry. And in this case, there was no sentencing entry until weeks after the indictment. He did not even have a sentencing hearing until a week after the indictment.
Which, okay.
And I note that the state has relied heavily on Monteleone, and this court found that the prior no contest pleas were sufficient to raise the level of the penalty. It was still the same level of an offense, a first-degree misdemeanor, but since it was a 3rd and 6, or a 5th and 6th, whatever it was, it raised the level of the penalty. And that's the distinction between this case and Monteleone. Monteleone only raised the level of the penalty, not the level of the offense. In this case, they're trying to use what they are deeming as a prior conviction to raise not just the penalty provided, but the level of the offense itself. And that's with what Mr. Graham takes issue.
The level of the offense is what raises the penalty.
In the Monteleone case, the level of the offense stayed a first-degree misdemeanor. It's an OVI. But because he had priors, the penalty as far as a fine or mandatory jail time, a 1st and 6, 3-day mandatory minimum, 2nd and 6, 10-day mandatory minimum. It raises the penalty, but it doesn't raise the level of the offense. It stays a first-degree misdemeanor. This case, we went from a first-degree misdemeanor to a 5th-degree felony.
Let me ask you a question.
Yes, ma'am.
The event that sparked the first instance, although it wasn't sentenced until after the event that sparked the sentence instance,
Yes.
he was found, how do you the first case, even though the sentencing entry didn't come out later, the event that triggered it, does that have anything to do with the timing at all? The events that triggered these things that happened afterwards?
If I understand the question correctly, I think that it does affect this case. The first case does affect this case. Because in this case, to which we are appealing, there had to have been a prior conviction to raise the level of the offense. And had Mr. Graham been sentenced and then committed the second offense, I don't think any of us are here today on Mr. Graham's case.
So the overlap's the problem.
Correct.
Okay.
The problem is, I don't believe that until he was sentenced in the first case, he had a prior conviction. Unless he would have pled guilty. The statute allows that, but he did not plead guilty. He pled no contest. Well, if there are no further questions, I will reserve the 5 minutes.
You've actually got 7, but I can only give you 5.
That's fine, Your Honor.
All right.
And I may not need it. I will turn it over to Mr. Giglucci. Thank you.
Good morning again, Your Honors. Mr. Ash, may it please the court, I'm Vince Vellucci, Assistant Medina County Prosecutor for the appellee in this matter, the state of Ohio. Your Honors, Mr. Graham is asking this court to do something extraordinary in this case, something that would produce an absurd and unintended result from the legislature's perspective. I think Mr. Ash has set out the facts pretty well. I'd just like to reiterate, so what Mr. Ash is advocating for would actually reward criminal defendants who violate protection orders so quickly that they haven't even had time to be sentenced on their prior order. That's a dangerous outcome, first of all, for the public of the state of Ohio and for the public policy of punishing repeat violators of protection orders. That's the whole point of the statute. So if this court did accept Graham's argument, it would go against this court's own precedent, first of all, with the Monteleone case, and I'll get into that a little bit more in a bit, it would also give a huge windfall to a repeat violator of a protection order. So the critical question here is what does convicted actually mean? And this court directly answered that question with its holding in the Monteleone case. And it answered that question to say that convicted refers only to a determination of guilt. It does not include sentencing upon that determination. The Supreme Court of Ohio has held the same in the case of State ex rel. Watkins v. Fiorenzo. That's 1994, Ohio 104. And the issue in that case, it was actually a theft in office case. And the question was whether this guy who'd been convicted of theft in office could continue to stay in office despite having not been sentenced yet. And the court actually said no, there's already been a determination of guilt. He pled no contest and was found guilty. Just because he hasn't been sentenced yet, that's just a formality. He's already been determined to be guilty. We can't allow this guy to, on public policy grounds, to continue holding office just because there hasn't been a formal sentencing. Now, the appellant's whole argument is based on this State v. Gwen, 2012 Supreme Court case. And that case, of course, one paragraph of that case at one point says that conviction includes both the guilt determination and the penalty imposition. Now, that statement, however, will not be found in the court's syllabus. It was not part of the court's holding. That statement was dicta. It went way beyond the facts and issues before the court in that case. There was a narrow question certified to the Supreme Court. It came out of this court, actually, in that case. The narrow question that was certified at the Supreme Court of Ohio in Gwen was whether, for purposes of enhancing the offense level in a domestic violence case, the state is required to prove the prior domestic violence convictions by providing a judgment of conviction executed in conformity with Criminal Rule 32C. So the question there was, how do you prove a prior conviction? It was not what is a conviction. So that's a very important distinction. The issue before the court in that case was, how do you prove a conviction? And the court's answer to that question in Gwen was, you do not even necessarily need a formal time-stamped judgment entry of conviction to prove a conviction. You could actually prove a conviction. For example, in that case, it was proven by the defendant's own admission that he had a prior conviction. And can also be proven by testimony, for example. That was the issue before the court in that case. But they said, if you do use a judgment entry of conviction, then it has to comply with Criminal Rule 32C. Those are the two holdings in Gwen. The other stuff about, well, what is a conviction or not a conviction is dicta. It's not binding on this lower court. It's not binding on this court. What is binding on this court is its prior on-point decision in the Monteleone case. And I know Mr. Ash has attempted to point out that elevating the, in the DUI context, when you're not actually elevating the level of the offense, you're just elevating the penalties, should somehow be distinguishable. It shouldn't be. And an enhancement is an enhancement. And there's been no case law cited by Mr. Ash or anywhere that's distinguished between those two situations. An enhancement is an enhancement. There's no case law to support that that should be treated any differently in this case, just because it was elevated from an M1 to an F5, that should be treated any differently. I would also mention that the state did not even have to prove a prior conviction in this case, because the case never got to trial. This isn't even a preliminary hearing, this is a plea. Mr. Graham admitted his prior violation of the protection order when he entered a no contest plea in this case. So in Gwen itself, I just mentioned that the court found that you don't even necessarily need a judgment entry of conviction. You can prove it with the defendant's own admission. That's what happened in this case. When the defendant entered a plea of no contest, one of the facts alleged in the indictment that he admitted to with his plea of no contest was that he had a prior conviction of a protection order. So he's admitted that. There was nothing in the judgment entry that...
What about his contention that by entering a plea of no contest, it can't be used against him in future civil or criminal proceedings?
Well, I don't think there's anything in that judgment entry that specifically reserved this issue or said that I'm not admitting to this being a conviction. Like he had just mentioned that. There's nothing in that entry that says that. And the plea itself cannot be used in the future. However, the conviction, the resulting conviction, can be used against a criminal defendant. And as the Monte Leon court says, there's a conviction here. Because sure, he pled no contest, but Judge Chase over here in Medina Muni found him guilty right at the time he entered that no contest plea. So there is a conviction, and that can be used, even if his plea cannot be used. So that's another distinction there. So all these cases, there really isn't directly on point in terms of this issue. Most of these cases have to do with how do you prove a prior conviction, and then that's where Glenn goes. It says how does the state actually do that, and that's the issue. That's not on point. This case, this Monte Leon case I've been mentioning, is on point, and even this other Supreme Court case, this Fiorenzo case from 1994, that theft in office case I mentioned, that's actually more on point in saying, answering the question directly, and that being the actual holding that conviction is a determination of guilt. And I would get back to the point that Supreme Court makes in the Fiorenzo case and that I made earlier, that it really would produce an unintended and absurd result. And Supreme Court has also said that statutes should be interpreted to avoid absurd results. And what this would be doing, again, would be to reward Mr. Graham for violating his protection order, the same protection order, again, 2 weeks after he just entered a no contest plea in a prior case. Just because he hasn't been formally sentenced, then we can enhance it to the felony. Now this, if this were to be the law, if this court made that the law, then attorneys everywhere would just be advising their clients, plead no contest, and set out sentencing as far as you can. And you can violate this protection order again with impunity, and you're going to have misdemeanors only. That's the most you could ever face. You can violate as much as you want. There's no way that is what the legislature intended here. This court has previously held the opposite because it wanted to avoid that consequence, and it can still hold the same here because the Glenn case is not binding on this court on that point of what is a conviction. That is dicta, and it was not a holding of the court. You will not find it in the syllabus. It was one paragraph out of that decision. And I think the court even says at the end of Glenn, it says, while we may disagree with the lower court's rationale, we still affirm its judgment. So I think that gives even more credence to the fact that the whole discussion on what is a conviction is dicta that's not binding on this court. So again, the crucial issue is whether there's been a determination of guilt, not whether the defendant has been formally sentenced. And on that basis, I would respectfully request that this court affirm the judgment of the trial court.
Thank you.
Thank you.
And you have, I think, 5 minutes.
Thank you, Your Honor. Hopefully I won't take all of it. When Mr. Viglucci talks about the Monteleone case, and that is this court's decision, in holding that Monteleone's 2 prior determinations of guilt for OVI offenses were the type of findings contemplated to enhance the level of penalty and not the offense. The 9th District Court of Appeals noted that while the existence of 2 prior convictions in the Monteleone case would increase the penalty, it did not elevate the degree of the offense. And that is why Monteleone's pleas of no contest and the filing of the BMV records were sufficient. because in Monteleone, the level of the offense was not enhanced, just the penalty. In Gwen, the Ohio Supreme Court said, when the state chooses to prove a prior offense through a prior conviction, the judgment entry of conviction offered must contain 4 elements described in Criminal Rule 32C and in State v. Lester. Additionally, the Supreme Court has said that a conviction consists of a guilty verdict and the imposition of a sentence or penalty. That's State v. Whitfield, 2010, Ohio 2, second paragraph, citing State v. Gapin, 104, Ohio State 3rd, 358, at paragraph 135, and State v. McGuire, 1997, 80, Ohio State 3rd, 390, page 399. Conviction consists of a verdict and a sentence. 29, 19, 27, A1, violation of that statute is a misdemeanor of the first degree, unless there are prior convictions or a prior guilty plea. And in this case,
So if he were, as the state argued, if the defendant violated 15 times but never pled anything but no contest, is he ever convicted?
theoretically, I think what you say is true, Your Honor.
He would never be convicted because he never pled guilty and he was never found guilty.
In-
Meaning there was never a jury trial, there was a verdict that he was guilty. So he always pled no contest.
But in reality, I don't think he would make it to 15 times before you would have a sentencing hearing
Why
on
not?
that first or the second.
Why not?
Well,
If it happened once, why can't it repeatedly happen?
sure. Realistically, when you are let out on bond and you violate the second time, you're going to be taken back to jail and you're going to be incarcerated, and you're probably not going to be given another bond because now you violated a second time. So you're going to sit in jail until your sentencing hearing on the first violation. You may also sit in jail until your sentencing hearing on the second violation.
Maybe.
More likely than not. I agree, it's possible, and technically it's possible someone would be able to bond out and violate 5 or 6 times in one afternoon. That may be. But now I think we're starting to get into the legislative function of our government. If the legislature wants to make a change to the law and say, you know what, the way we wrote it, it gives defendants an out to keep violating until they either enter a guilty plea, are found guilty by a jury, or have a sentencing hearing after a no contest plea. So let's change the law. I think that's what would be required. I don't think it's incumbent on this court to say, well, what the legislature meant was, so we're going to change it. The law is, it's a misdemeanor of the first degree unless you have prior convictions.
And now I'm going to have to stop you. You've run out of your time.
Thank you, Your Honor. Thank you for all of your attention.
Thank you.
Have a good day.
Same to you.